Binghamton Scots. Hello.
Hello.
From the mountains of Binghamton.
The mighty hills, yes.
Where the Susquehanna floods every spring.
Can be bad, can be bad. For
It's one of my
sure.
earliest Girl Scout memories is they brought a bunch of us down to Corning to help folk out their houses, and people thought they were getting professional help, and there were a bunch of 13-year-olds. They were not happy. Oh, it was.
That's everyone that was in the waiting room. So, oh, never mind. We got another one.
Well, welcome, Scott, and John, and Derek. This is, oh, and here's Herbert.
Hello.
Hello, Herbert. How are you?
I'm doing well today. How about yourself?
Great.
Hey,
I
Molly.
hadn't met you
There you are.
before, and now I'm running into you everywhere.
Everybody keeps pointing to Molly being the person that we need to connect with. So I'm glad we connected.
Well, and I need to connect you with the team here, which we have four of us. So just by way of introduction, this is a relatively new event we're holding, Ask the Expert, and the expert is the team here at the Innovation Law Center at Syracuse University's College of Law. And I'm Molly Zimmerman. I am an attorney, but my role is to coordinate research with students who can do great research. And I'm here with Carly, my colleague, and then two of our professors, Brian Gerling and Dave Eilers. And I'll let them tell you a little bit about their background. And then we can ask if you have any questions. And we do have a few questions that were submitted. So Brian.
Sure. Thanks, Molly. Good afternoon, everyone. Again, Brian Gerling. I am a practicing attorney here in town in Syracuse, but also a member of the adjunct faculty at the College of Law, the Innovation Law Center. As Molly said, even though we're practicing attorneys, our hats, our roles here today is to not provide legal advice, but we'll try to answer your questions as best we can. With that, I'll turn it over to the other adjunct faculty that I see on here, which is Dave Eilers. Dave.
Yeah, thanks, Brian. So Dave Eilers, in addition to the Innovation Law Center and helping out in a course on technology commercialization, I teach corporate entrepreneurship in the Whitman School of Management, have a background in medical devices. So I like hard things with regulatory hurdles. It's a short bio. So thanks for joining, and yeah, looking forward to your questions.
Just a little bit more background about the Law Center. It is a research center that has the law students work with business students and sometimes engineering students to understand the intellectual property, regulatory, and market influences to commercializing new technology. So as Brian was saying, we don't provide legal advice, we provide research that helps make some of these important decisions. Before we get started, I'd just like to see, does anyone have questions, or would you like us to, if not, we'll move into some other ones, but if any of you have any questions, we'd like to start with those.
So when you say questions, you mean like more specific to the company, like why we're here and we're interested, or just kind of more general questions about the program or Syracuse University, or?
Pretty much whatever
it can
you
be
have.
anything you'd like.
Well, then,
obviously you're not going to want to talk about any confidential information having to do with your invention, but other than that, a lot of the questions are of interest to anybody trying to commercialize a new technology.
Yeah, so I guess I'll keep it a very general, high level. Maybe this could help other startups. We're obviously in upstate New York, right? It's not like we're in Silicon Valley. There's resources abound. So we're looking for resources that don't cost $100,000 to help us understand a path right forward. So we are a software company. We're not hard tech, right? This is soft tech, I guess. And we were able to we just assume we're just going to keep all our scripts in the cloud, right? And we're not going to publish them, just so someone can change 20% of the code and be like, hey, it's something new. Look at that. We didn't want to do that, but come to find out, there is a process that we actually created that we've been told by business experts that we really need to look into and understand. Is this something, right? And so there's a process patent, I guess, question. So I'm just trying to keep it very general, so maybe it applies to other people on the phone without going deep, but that's kind of where we're at. I'm just kind of, we just need resources. We're a small startup in upstate New York, and I'm sure there's lots of IP attorneys that would take our question for lots of money we just don't have. So I guess I'll put it out to the team
We have a
here.
great guidebook called IP Rights and Software, and it explains exactly what you're talking about, that the way you protect software is as a process. And what you do is you disclose the architecture of your algorithms and how they interact to complete the process that you want. And what the students would do is take a look at other process patents in that space, so you could be aware of what was there or not. And I'm sure Brian has a lot to say about, like, there's pros and cons of doing this. And while he's talking, I'll get the link to our guidebook and put it in the chat box.
Oh, great. Thank
I
you.
already put it in the chat, so it's
Oh,
there.
thanks, Carly.
See it. Perfect. On it
Yeah,
now.
just to piggyback on what Molly said, several years ago, folks were trying to secure patent rights to the actual code itself, and the process is lengthy. And by the time the patent issued, the code was obsolete. So it kind of defeated the purpose. So then they kind of transitioned to, well, let's copyright it. And that's, again, is not a lengthy process, but it's literally requires the putting of zeros and ones on a page and filing it with the Copyright Office. So now the thought is, within the practices generally is, keep the code as a trade secret, but then protect the process, the application, whatever the software is doing, as a method patent. So that is definitely sage advice and something you should look into. Once you refine whatever it is you're doing. I mean, there's no reason to file for a method patent, until you've kind of focused in on exactly what it is your code's going to do and the applications that it's going to have. So, usually you want to file what's called a provisional patent application kind of early on in the process. The key with that is, though, you need to disclose enough of what your application would be and what it's going to do, such that you can secure enough protection and keep people out, right? So the name of the game in patents is keeping other people out of your space so you can monopolize that area. So it's a delicate dance. It's kind of, figuring out what juncture should we be filing for a provisional application on the method. So, without knowing too much about the technology, I'm just kind of keep it at a general level here, but that's kind of your path forward.
Thank you, Brian. I guess a quick follow-up question to that. Is there a resource that we can review that kind of, as a general framework, can say, well, listen, if you're thinking about your technology as a process, the way that your competitor could manipulate that process is by doing X, Y, Z, changing this. Think about, how you can guard against, your competitor changing X, Y, Z in your provisional application.
Yeah, I mean, it's to work with a seasoned patent attorney to make sure you're capturing as broadly as possible, and not necessarily your provisional, but on your your full blown or non-provisional application, right?
Right.
So it's kind of an art. You want to disclose enough of what's in your provisional application so that you can relate back when you write your full-blown application. And that's where you try to make it as broad as possible and think of any and all applications and methods that, that you could utilize out of this. So that's really the name of the game, and where the attorney, the art of a good patent attorney comes into play.
Okay.
The other thing, oh, sorry, Herbert. The other thing you might want to comment on, Brian, on the provisional that'll benefit everybody is the inventors, because once your provisional is in, you can't really add inventors, correct?
True. Yeah. So what Dave's talking about there is, there's a couple of different things at play when you file a patent, one of which is a duty of candor to the Patent and Trademark Office, which, not getting into the weeds here, but it's essentially disclosing any and all references that you're aware of that, is similar to your technology, and you're not 86ing something so that the patent examiner can't find it. And so you have an obligation to disclose, what you found, your cited references, it's called. And here's what we think is similar to, what we're doing, but we're different, and we'll explain why we're different in the patent. So another part of that duty of candor goes to the inventorship. So, typically it's easy whether you got two inventors in a garage and they come up with an idea, and now they both have been in the design and conceptualizing of it, but then also reducing it to practice and making a prototype. Where it gets a little bit dicier is, you've got multiple different inventors, and particularly in a software or in a method, you've got, the person who's, come up with the code. You've got other people that are coming up with the applications for that code. And so the key is to identify, who the true inventors are. Because if down the road, for example, you cut out somebody, they can contend that they're an inventor on this patent and either invalidate it or sue you to say that they are. And now you've got a patent that's worth 10 or $20 million. They're going to come out of the woodwork and try to get their piece of the pie there. So it's kind of, and to be an inventor, it's not like, oh, hey, I thought of this and I should be an inventor. It's, they've got to be involved in the process and document everything that's going on. So as early stage, startup companies, it's pretty important to keep, pretty detailed notes of like who's doing what and who's contributing what. We've had cases where, it's a PhD student and the professor has spun out a company, and, this PhD student is contending that, we've had it on both sides where the PhD student was right and got cut out of the licensing rights or the royalties. And on the other side, they contended they were part inventor, and, they did nothing to, contribute to the invention whatsoever. So, we've seen it go both ways, but, it's just kind of important to keep a documentation of what's going on and who's doing what, so that in the event that there ever is some type of challenge, rather than just you testifying from your memory, you've got, hey, look, we've kept copious notes of what's going on here, and here's what I did on this day, and here's what the person contending they're an inventor did. So
That's really helpful.
documentation's key.
Yeah, very helpful. Thank you.
One of the other things to be aware of is that, one of the reasons to get this research is to be aware of what the competitors have, because there is a whole school of thought that says, just go forward, get customers, don't spend your money on patenting. But then, strategically for getting investors, you may want some kind of a patent, and most patent attorneys can get you some kind of a patent. The issue is just how broad it is and how useful it will be to you. And that's why the research would be interesting or important. And the other thing is business method patents. There's this case called Alice that called into question business method patents and sort of raised the bar for getting them, although we'd probably still be able to identify a number of patents for you to look at. But we worked with this one company once, And they ended up saying, I wish we had this before we spent all this money on trying to get a patent. But with regard, we've got some other members of the team here. So Jack Rudnick is the director of the program. Let him introduce himself, and Dom Dana and Caitlin.
Yeah, I'm sorry. We were just talking to a bunch of really smart engineers from Alfred. So anyway, I'm sorry we were a little late. I'm Jack Rudnick, was the attorney for Welch Allyn Medical Devices, where we practiced entrepreneurship and a lot of neat technology that was commercialized in many places besides medical devices. I love it so much, I decided to hang out with these people and continue to do things like that. Dom?
Dom Dana, I work with Jack at Welch Allyn, and about 5 years ago, he asked me to join, and I love working with the students. My background is not law, it's chemistry and electrical engineering. I worked in research and development in Welch Allyn for many, many years, and love what I'm doing now. It's fun. Students are great.
Caitlin's one of our senior researchers. She's excellent.
Yeah, so as Jack said, I'm a third-year law student, and I'm one of the senior research associates at the Innovation Law Center. And I have undergraduate degrees in politics and chemistry.
Hey, Molly, before you move on, just to close the loop on this provisional application question. So the other key thing that a provisional patent application does, so timing is everything in the patent world, right? So you've got 1 year from the date of disclosing your invention rather, which can be an adventure, and file for patent protection for that. So what a provisional application allows you, it basically buys you a year. So if you're like, oh shoot, we published this paper 6 months ago, or we presented this thing at a trade show and not under a non-disclosure agreement. The clock is running potentially, that you need to file your patent application. You're within a year of that disclosure. Otherwise, you've dedicated it to the public and you've lost all patent rights and your ability to exclude others. So that's another, tool that you can use, or your patent attorney can use, to kind of buy you more time, was with a provisional application.
I have a question sort of regarding that. What kind of protections do we need, I should take if I have an idea that we'd like to patent, but we don't want to submit the provisional right away because we know that 1 year clock starts ticking, and after that 1 year we might be due $5,000 in fees, and we might not be ready to pay out that. What kind of steps should we take to protect us from publicly disclosing our I'm guessing it's simple, but I don't know, me telling my father about the idea, is that going to get me in trouble, or
Yeah, no, so typically it's you'd be showing it to a company or a potential investor, right? So you want to make sure you got non-disclosure agreements that keeps it secret. That's not a public disclosure, so that it's going to start the clock. The other thing is, even if you don't have a non-disclosure agreement, if you're telling somebody generically what you're doing, that's not enough. It's got to be, the disclosure's got to be sufficient enough that it's called a person of ordinary skill in the art could take what you're telling them and make what it is you then want to patent. Now, they could be recording it. They could, you never know. So, you want to talk in very general terms. And then if somebody wants to sit down and get more specific with you, then anybody who's is credible is going to be more than willing to entertain signing a non-disclosure agreement. They may want to talk about the scope of it, but that's how business is done these days, because the days of the entrepreneur going to the large company with no non-disclosure, and then they say, well, geez, thank you very much, it was nice meeting you, and then they pick up the phone to the engineering department and said, come here, I want you to do this, and then they just cut the entrepreneur out. And then unfortunately that happened all day long 20 years ago. But so now with anybody who has credibility and that you want to be somebody you want to work with is going to be okay with, signing a non-disclosure agreement. Now, again, they may question the scope and, the actual language that goes in there, but they should not have a problem with non-disclosure agreements.
When we were at Welsh,
Although
we
there
did
is-
a lot of ideas, but I got to the point where I was saying, let me know, when you get a patent, come talk to me. Because it's full of trappings. And we come up, I have no idea what our people are working on in R&D. They're really smart. And they could be working on something similar related. And then all of a sudden, 2 years we're in the marketplace, and this guy that came to us with an idea, also, that was my idea. Companies. are
Yeah,
very
and so that's also a really good point that Jax brings up is, you'll have these business advisors and people that want to talk to you about, oh, let me, talk to you about this process or how you can enhance that. You need to make sure you're documenting those conversations, and that's all part of the non-disclosure, because just like Jack said, 2 years down the road, you've got this multi-million-dollar product that's protected by the patent, and they'll say, hey, I was an inventor on that. I want my royalty based off of that patent. So those are other pitfalls to be careful of. But I think what Molly's going to talk about on an NDA is in the context of a trade secret. So what we're talking about is patenting an idea or an apparatus or a method, but it may not necessarily be the case with a trade secret. So is that where you were going, Molly?
Well, actually, I was just going to ask Dave to talk a little bit about why companies are sometimes reluctant to sign NDAs and workarounds around it, which is that
I
your
can-
question, Dave?
Yeah, I can address that, and then we can get back to the trade secret topic.
Okay.
On the company side, and Jack and I worked together at an offshoot called Blue Highway. And our job there was we lifted out the advanced R&D team from Welsh Allen, which Dom was on that team. And our job was to look ahead at future technology. And, I'll just name an area. So let's say it was diabetes. And we would have 3 or 4 bets, technologies that we were tracking or maybe co-funding. And so if an inventor came in and said, hey, I want to talk to you about my diabetes device, well, that's too broad. So tell us, what your, technology is. Is it contact? Is it non-contact? So there is some reluctance. There is also companies like Procter & Gamble, let's say, that have a discrete port of entry called Connect and Develop, where companies will say, hey, here's technology we're looking for. And if you have something, let's get together and talk. But there again, you have to be sure that, it's on the company side, you want it to be narrow. On the inventor side, you want it to be broad. And you just have to come up with a compromise so that you can agree to talk about what it is, excluding the trade secret part. So that's what we're going to tackle next. Does that make sense, by the way? Okay.
Yeah, Brian or Jack, did either one of you want to tackle that? That is a question that came to our attention just this week about some of the concerns about if you are trying to license a trade secret, is an NDA an effective method to continue to protect that?
Yeah, I mean, I'll just real quick. So the concern there is right. You've got no other recourse. You've got no other source of protection when it's a trade secret. And so you're going to divulge your baby to whoever it is that you're dealing with. And the trouble is you don't have, a patent application to rely on to say, hey, I've already got this provisional on file. Clearly I filed it before the date I, was talking with these folks. This is my invention. You've got a paper trail that you can rely on. The trouble with a trade secret is it's just that, right? It's a secret. And so, it's eventually it's going to be your word against their word as to what was exactly disclosed. unless you're disclosing in great detail what it is your trade secret is in the non-disclosure agreement, which can be a little dicey. So the preferred way to handle that, and in fact, I just had a client the other day that had, there was a code versus a developer issue, and they just wanted the non-disclosure agreement. I said, we really ought to be drafting a license agreement which has non-disclosure provisions built into it. But that way, we've got a license agreement in place. We know what money we're getting and who's doing what, et cetera. And it's all spelled out in an agreement. And there's your paper trail that you can rely on to go back into court or whatever you need to do to enforce it in the event that they misappropriate your trade secret.
I agree. I would not count on a non-disclosure to protect your trade secret. Most people overlook that's what lawyers do. We read every damn word of one of those things, and you'll find the clause there that says after 3 years, the obligation not to disclose is gone. Trade secrets are meant to be secrets forever, as long as you can keep it a secret. So even just something simple as that, a business person or an R&D person might miss that non-disclosure. After 3 years, no one has to keep anything a secret. So the agreement, that one particular form, is inappropriate. There's ways to disclose the value of your ideas. There's ways to disclose what revolutionary consequences there are to your technology without disclosing the secret sauce. And if you are going to disclose the secret sauce, the guy's going to have to put up his firstborn as ransom or something like that, because somehow you're going to have to make sure they don't tell the secret. It's very difficult. But inside companies, I was at Oneida Limited as well as Welch Allyn. We had some amazing internal processes that were trade secrets. We didn't tell all the employees these were trade secrets. They didn't even understand how some of that stuff worked themselves. Perfect. It's hard. Trade secrets are good, but they're hard to keep track of. Get a patent. If you can get a patent and it makes sense, do that.
Is there any follow-up on that?
I've got a
Yeah, if
story.
I could ask, oh, sorry, go ahead, Don. Sorry.
I just have a story about that. Welch Allyn and General Electric were competitors in little light bulbs for medical instruments. And they made halogen lamps. We made halogen lamps. And we bought things from them and we sold things to them. So we were friendly, even though we were competitors. And the president, Howard Zellinger, remember Howard, invited me to the company, and he was so proud of his lamps. And we took me into the lab, and he wanted to show me what they did. And there were tanks of gas there with the formulas of the gas written on the tank. And basically, I looked at it and memorized it, and I didn't steal it. He gave this trade secret away unknowingly. He brought me in and showed me the trade secret, and I took it back and we did it, and we made lamps like them and then like their lamps, but we improved it. So you got to be really careful. And as Jack says, there's marketing people that'll give it away, and then there's like the president of the company will give things away without knowing what he's doing, and they like to brag, and so you got to be really careful. And basically, they gave it away, and they knew that too after. They said, "Oh my God, what do we do?"
The advice is stay humble, don't brag.
Yeah. Well, and then one way for the, companies here to kind of limit that is when you have people come to your lab that you want to show, if you haven't already had them sign a non-disclosure, you can have them sign in, and then on the sign-in form, you have a blurb up top that says, your visit today is under a non-disclosure agreement. Anything you see here today is protected, and then they sign their name, and, but it's not ironclad, but it's at least another, fact you have that were you ever to go and litigate these things, you're like, Judge, here they sign their name to this thing, and they still went ahead and misappropriated my trade secret.
One of the things we see with we're mostly dealing with tech startups, and a group of really smart people, friends, usually lab mates, whatever, but they're their buddies, and I mean, including females there as well. Things aren't always that good, and that person, one of those people might leave. Or in Welsh Allen, we might have a disgruntled employee that left. You need things in place, processes or employee agreements, not that you agree to employ, but what the employee agrees not to do. And that is not to take those trade secrets. And we had one guy, he took his laptop. We actually we searched and seized his home, took his laptop, took all of his laptops, all of his tech equipment, took it right out. And every right to do that, both in the US as well as in England. So you have rights as an employer to keep your trade secrets against employees that might be trying to steal them. And I mean, it was sort of draconian, but we had to do it because it was, I think might have been one of our LAMP formulas, Dom, I'm not sure. But, and then there was the Wake Up software code and things like that. Really important things. We clamped it right down on the employee once we found out what he had done or she had done. So you don't need to be a jerk about it. You don't need to be a heavy hand. You just have some basic fundamental agreements in place so people know what they can and cannot do if they leave, or even while they're still working for you. You'll need that paper, and it doesn't have to be. They're on the form books. You can find things like this. But it's a good idea, especially at the initial stages, because I think that's when most of these things are overlooked by the startup. And you're all buddies, and God bless you, but you're all buddies. Look what Zuckerberg did to his friends.
Can I ask a question about that? So,
Yeah, we just heard about that yesterday with one of the inventors that that the two of them were working together, and then it was just an ugly breakup. And so Jack, we're thinking exactly the same. You know, in addition to an NDA freestanding, you can have an NDA as a part of an employment agreement, as part of a license agreement, and then also the founders agreements can be really important. Before you decide what kind of a business entity you're going to form, it's a good idea to at least agree with your co-inventor or co-founder to assign any and all IP to an entity when that determination is made. And that's another guidebook we have that maybe Carly will put in the chat also, because there's just, as Jack says, at the beginning, you just feel like you're on this journey together, but things invariably happen. Scott, did you have a follow-up on the
Yeah, if I may, yeah.
John.
If that's all right. So yeah, I wanted to pick up on something maybe Herb had mentioned and gotten some feedback on from Brian and others experts. Let's say in the realm of, I think this is pretty common and actually probably increasing as an issue. You know, say in the realm of software or let's say a service that's enabled by software and towards the customer, right? The company has developed this and it's made available to their customer on some transactional basis. Now, right, the question becomes, should that form of IP protection be patents? Should it be a trade secret or even maybe copyright? But, right, what would you say? I know, you know, I don't want to give too many, I really don't know, but I don't want to get too specific, but just in general, how would you look at that issue in terms of deciding what form of IP protection to use?
So like on a software as a service or a platform as a service type?
Yes.
Yeah, I mean, you can get the method covering, you know, the software as a service, you know, what it is you're doing. You can break that down into the method of how, you know, whatever the output is of that particular software. You know, similar regard to you know, platform as a type of, obviously your platform is going to be made up as a series of different type of methods and applications. And so you may need a series of patents to cover that, which would be called continuations or continuations in part, as you further, you know, refine and grow from a service to a platform, if you will. But yeah, that's typically what's done now is protecting the method, the software as a service, under a method type claim. So you can have a method, you can have an apparatus, type claims going to that if it's tied to an overall, hardware system or, so something like that. But typically the method alone is going to provide your coverage for the software as a service.
But say the company developed their logic, the engine for that, and that's not, the customer is not going to be able to figure that out, or at least readily. Could that be maintained as a trade secret?
Yes.
I think that's that is one of the biggest decisions with these software things, is to go trade secret or patent. I mean, Brian is so right, like patent attorneys can get you a patent on that, but do you want to be disclosing the architecture of how the method works, especially as you say, if it can't be reverse engineered. So I think one of the main reasons that people go for the patents is because investors like to hear about it. And that's why sometimes, when you file the provisional patent application, that doesn't get published. It's after you file the non-provisional that 18 months later, that's what gets published. So sometimes people will file that provisional as a way to sort of entice investors. But an investor that really knows what they're doing is going to understand the difference and want to see the inventive aspects of your architecture.
Thank you for that, Ma. That's a really interesting
it's a tough
strategic concept around, they're not just about patenting things, it's about why you'd patent and the other players that are involved and what they're viewing as a patent or not. And obviously you don't want to mislead any investor, especially during due diligence. It's going to get found out. So that's a great point. Thank you.
No,
So a
and
couple
then
of things that, oh, sorry.
No, I was just gonna add one quick thing. So the strategy with, any patent is to get as broad a scope as you possibly can in your claims with disclosing the least amount of information, right? So you've got to be able, there's an enablement requirement and things of that nature, but that's really where the key comes into, the art of the patent attorney is, how broad can I get the scope of protection with disclosing the least amount of stuff? And that kind of plays into, the software versus, the method type patent. So, and it harkens back to the days of manufacturing. I mean, you wanted to patent the article of manufacture, the end product, but you didn't want to disclose the process of how you made that, because really that's where your value is and that's where your moneymaker is. And with a patent, you're disclosing all of that to the public to come in, and people like Dom, and Dom did it very well, would come in and read these patents and figure out like, oh, here's what they're doing and here's how we can design around it. So, that's kind of the yin and the yang of the patent process.
I was just
I
two
think, Dom, would
things.
you, because you've talked about that before. Oh,
So I was just going to interject
ahead,
something
Dave.
about funders, because we talked about, so venture capitalists for the most part will not ever sign an NDA because they have so many solicitations coming in, and it's not really their business. They don't create stuff, they loan money and they create value. They don't create stuff. So they will never sign an NDA. Doesn't mean you have to show them everything, because, people could leave that venture capitalist. One quick story, sort of like the one Dom told. So I worked for a wound closure company, and the inventor had invented this atraumatic suture needle. So think of a 3,000ths hole in a 9,000ths wire, and it was for eye surgery, very hard to do. Johnson & Johnson, Ethicon, was their biggest customer. And as they did their quality solicitation and they didn't have them sign a logbook, they eventually stole the process. And then Ethicon started to file patents, unbeknownst to the inventor, Ben Sulsley. So obviously that went badly. As a result, anytime you entered the plant as a visitor, you did exactly what Brian talked about. You signed the book and you acknowledged that you had a duty to not disclose anything you saw in the factory. And for some, and you know, our biggest client was Tyco, which became Covidian, which became Medtronic. So those people had to sign too. And there were some customers, some of the overseas customers, where we actually had blinds on some of the areas in the factory, so they couldn't see some of the things that were going on. They couldn't inadvertently, you know, look over somebody's shoulder on a computer and see a password or something like that. So those are all the things you can do for that duty not to disclose.
One other quick story.
you.
When we were developing the endoscope, we had a lot of trade secrets. And Olympus, our biggest competitor, which we sued and won actually, but biggest competitor tried to get Syracuse University students to apply for a job in the summer at Welch Allyn to steal our secrets. And we found that out when we were in litigation with them. And there was discovery, and we saw they actually tried to recruit.
Wow.
Fortunately, they didn't have any success. No one wanted to do it, but they actually tried to steal it. And it was amazing. We couldn't believe that they did that. But they did.
You've talked a lot about that inventions at Welch Allyn would often be protected by, you know, not only a utility patent, but also a process patent and a trade secret, and maybe even a design patent. Can you talk about some of the advantages of
Well,
doing that?
on our, you make otoscopes and ophthalmoscopes. So there's a battery handle that's like that, and then you put the head on it, whatever, it's an otoscope head, or, and the connection mechanism. We patented that as a utility patent, but we actually patented that as a design patent. And the design patent was actually more useful because someone couldn't make that design and their head to fit in our handle. So we did both utility and design for that product. And we did that on many products. Unfortunately, design patents are only nowadays 15 years. They were 14 years, as Molly found out, we found out together. But patents are 20 years. So, but design patents are very useful. Yeah, we made landmines. Welch Allyn, we tried, there was a lot of competitors. We had all over Europe and the United States, we had competitors. And so when we came up with an idea, we made other small, maybe smaller, narrow patents, but we put, and that's a beauty of narrow patents. You put them all over and it just, someone looks at it and say, oh my God, they've got 15 patents in this area. And some of them are useless, but they're there. And I don't know, Brian could talk more about that, but the landmine really is important. If you have something, if you can patent, if you have enough money to do that, just put patents all around. And we've done that for many products. I don't know, any other questions?
It's such a challenge for the startups who don't have the
No.
funds to do that. And that gets back kind of to what you were saying, Scott. It's a very tough call. Like we could argue all day about which way would be better. So I know that's not particularly helpful, but they have those options. And sometimes the research can help because by understanding who is holding what, you know, who the competitors are and how much money they have, how likely they are to bring some kind of an action, that can be useful information.
Yeah, and Molly's absolutely right. It's, you know, it's a strategy, right? I mean, whether or not, you know, we don't have the money as a startup, so we, you know, can't file for a patent. So let's, you know, what does a trade secret really get us? Or, you know, and then as you grow, and then, you know, Dom, while I appreciate you pointing out, you know, I could speak to that. Jack is the architect behind that patent landscape strategy. I'm sure could talk much more detail about that as the architect behind it. But yeah, I mean, it's an IP strategy, and that you shouldn't just think like linear. I mean, there's other forms of IP protection that are available to you that can be a belt and suspenders type approach, or as you grow, as Dom said, laying landmines out there or get the competitors to look in the wrong direction kind of thing, or foreclose them from trying to even come into the market because there's so many different patents that they would have to get around. So it's really an IP strategy, and you try not to think of it in isolation.
I have to thank you for the credit, but the credit really belongs to Dom and the team in the endoscope area in particular. They actually, the engineers were reading more patents than the attorneys were. And it was interesting how they could see how the interplay or interrelationship of different technologies from different companies and where we would do or where they would do things. I remember when I went to work for Welch Allyn, I was very upset because I'm watching these engineers get bucket loads of patents, because that was before the internet, for God's sake, the dark ages. So they were actually got copies of patents, and Dom and Ray Leah and Gus and all of you guys were reading, and Bob Wood, they all were reading these things. They actually, in other places but now we have an internal patent department and they do all the strategy, Brian. But back in the Dom days, the engineers were the architects on the patent strategy, and that's a good place for it to be. Because they knew.
Yeah. And one of the things entrepreneurs should do is really research their idea. Find out what other people are doing, and you can do it with Google. When I was doing it, we had patent gazettes, and I'm not sure if they still, they're little 8x10, not even 8x10. They came out every 2 weeks, and we had piles of them. And one of my jobs was to look at the classifications for our competitors and look at what they're doing and find out where they're going and all that. And so that was one of my jobs, to look at those books so now it's so much easier with Google and software to do that. But you really need to know, you got to research. What a quick story is, we had a client come and he had a great idea for basically a tooth cleaning device. And he said, no one has done this since people use twigs to clean their teeth. Anyway, and so the first thing I tell the students is go on Amazon and see if you can buy it. And about half the time you can buy what people invented. And we found 7 similar products, almost identical, that you could buy. And one you could buy at Walmart for $30. And we asked them, did you know about this? And they said, well, yeah. They didn't know. They didn't know. They actually started a company. And so you really need to research yourself. I mean, just go on Google and Google it, and Google patents and Google Scholar. And that's the biggest thing you should do before you start anything.
Another question we often get is, can I file my own provisional patent application? And Dom, do you want to talk about what you were saying the other day as a caveat with regard to Europe?
Oh, you can. You can, and Brian and Jack know that you can file almost any form. You can do a slides, you can do a description, you can do almost any form as long as you follow certain rules. All the information's got to be there. There's a whole list of things that have to be there. The inventors, the date, and all that. But you can do it yourself. But if you don't put claim, you don't need claims. And the thing that I always wondered when I saw provisionals, I saw claims, and the patent was written like a real patent and it had claims. And I wondered, why did they do that? Spend more money on claims when they could do that at the end. And one of the reasons, there's a couple of reasons, but one of the reasons is European patent offices will not take the priority date of a provisional, US provisional, unless there are claims. If there are claims, they'll take that priority date. I mean, there's other reasons too, because if it's in a form that you can quickly turn it into a non-provisional, that makes it easier after the year. So, I mean, there's other reasons to do a good job and get an attorney involved in a provisional, but you don't have to. And they're inexpensive except for the attorney fees.
I just want to give people a chance. Are there any other questions? We did get one other question about trademarks, but I'm almost wondering if it would make sense to save that for our next session.
Yeah, I had some just questions about the program in general. Are we, is this the only place to sort of ask questions and also maybe get help on, like, my company, we're trying to figure out, what provisionals we might want to submit. And, we need, I'm doing research on my own into what patents exist, but like, I don't know, is there any way to get help on looking into what patents are similar, and if it's something is already patented that's, makes ours not like, it's not novel enough? Like, is there any way to help, like, you guys help with that, or?
That's what we do. That's definitely what we do. And we'd love to talk with you. We started doing this because of the pandemic. We're not able to get out as much, but we can schedule an individual session with the team to see what kind of research would be most helpful to you. Right now, we're scheduling, like, the actual projects will begin in May. Sometimes we can find students earlier, but I'm not particularly optimistic about that right now. But May will come quicker than you realize. And in the meantime, we could get an NDA in place and, exchange the documents that the students would start with. So if you just shoot Carly or I an email, we'd be happy to set that up.
Yeah, are they on the, I'm guessing they're just on the website, right? Or, oh, sweet, thank you.
Yeah, I'll put,
I just threw my email in
Yeah.
the chat too. But yeah, they definitely are on the website as well.
Awesome. Thank you. Appreciate that. And do you guys help with things unrelated to IP, like employee agreements and stuff like that? Or is this strictly just for IP?
Dave, do you want to talk about what else we offer?
As soon as I come off mute, yeah. So yes, in addition to IP and freedom to operate, we also take a look at the market landscape and competitive landscape, and also some of the regulatory requirements, particularly if it's a medical device, and can give you some guidance. We have a guidebook on this for FDA as well. So.
Awesome.
I just wanted to interject one story since we were telling stories. So I was part of a group of 100 companies, but 15 were medical. And one of those 15 companies that we had acquired, the person would actually, it was in the orthopedic area, and he would look for patents that were about to expire and become sort of public domain. And then he would make those devices and add a little tweak, and then he would file a patent on it. And that would become his competitive advantage. It was really very shrewd in the way he would do it. So not only are you doing the research to make sure that you can patent something, but you might do the research to get around somebody else's patent. And it was a good business practice, and it was a very profitable business that we acquired as part of the Marmon Group. So for whatever that's worth.
Yeah, we don't do, agreements are sort of provision of legal services. So we like to be sure people are aware of them and how helpful they can be, but we don't actually draft them or
But
review them.
there's some attorneys in Syracuse that we might be able to recommend.
Yeah, we certainly can give you, leads if you need that.
Yeah, that would definitely be awesome. I greatly appreciate it. So I'll definitely be in touch to work further with you guys. So this is a really cool program. I appreciate the help.
Do you want to tell us a little bit about your technology, the non-confidential aspects of it?
We're from Union College. Like, we came out of Union College. We worked with 2 professors, and then it's me and one of my good friends from school. We developed aerogels. It's a nanoporous structure that's has a really low density and is super insulating. And also the ones we make, which are silica based, have decent translucency to the point where they're almost transparent. And so we're trying to develop these aerogels for window applications, ones that will make a traditional double pane window almost as insulating, pretty much as insulating as a low end triple pane window at a lower cost. So yeah, we're pretty new to everything, you know, trying to learn as much as we can about business and really develop the technology. So we have a STTR grant from the NSF, and we're working with the Kaufman Southern Tier Incubator out of Binghamton. So that's how I found out.
Oh,
Well,
great.
that's great. Go Dutchman. I was there in the early '90s and played a little puck there, but
Oh, very nice.
ended up graduating from SUNY Binghamton though. So
Very nice. So, it's nice to
Well,
meet.
thank you all for attending. We hope you spread the word. And we'll look forward to maybe seeing you again next. We're now doing the second Tuesday of the month, Thursday, sorry. And I think next time we'll probably be talking a little bit about trademarks and any other questions that people want to submit.
Awesome. Thank you.
Okay.
All right,
Thank you
thank
Thanks,
you.
all.
everyone.
Yeah, thank you guys.
Bye-bye.
Yes, Scott.